Hey everyone, Harry here to talk about the last day of the United States Supreme Court official term. So every year, and there's really no other institution of government that's quite like this, they run like clockwork starting in the first Monday in October and going through around the end of June. And at that point, they rise is the term, and they're done for the summer. Now, they are not done. The pace of justice continues. And in particular, some of these emergency docket things we've talked about, including the really outrageous, abysmal use of the shadow docket from a few days back, that will continue. Things will trickle in during the summer, but they're gone off on their junkets here and there, and they don't officially return. This is the end of the so-called October term 2024, which goes kind of like a school year, 2024 to 2025. Okay. As of this morning, they had 10 cases left. They decided 2, meaning get ready for 8 tomorrow. As to the 2 that were decided today, there's a case that has sort of practical importance, but it's legally it's decided on fairly precise, arcane legal grounds. But it's a suit by Planned Parenthood and a woman who's receiving services from Planned Parenthood, which provides not simply abortion services that everybody zeroes in on, but other sorts of reproductive health services. Anyway, the governor of South Carolina issued an edict that says Planned Parenthood may not participate, or so-called abortion clinics, any place that gives abortion services, even though they give other services, can't participate in the state Medicaid program. And Planned Parenthood and a patient sued, and the Supreme Court rules today on technical grounds that the statute that they sue under, to say we have a right to this, and there is a provision of the Medicaid Act that says any eligible patient can seek health care from any qualified provider. The governor has basically made this no longer a qualified provider, and they sue, and 6-3 in the Supreme Court, with Justice Jackson writing for 3. Kagan and Sotomayor says you can't sue under this statute. Some statutes Congress passes, and in addition says there's a so-called private right of action. You can sue under it. Others it doesn't. This court, and for the last many years, really, the Supreme Court has been pretty damn tough and grudging about saying, here's a statute, and Congress maybe wasn't clear, but there's a private right of action. You can sue. It used to be the law that there was a 4-part test, and the court would find you have a right of action. Now more and more they don't. In fact, one of these almost never do they. And here, 6-3, they say you can't sue. So even though you may, in fact, have a right under the Medicaid statute, there's nothing you can do about it. That's the law, as it were. So that's the ruling from today. And there's another one that's pretty unremarkable. And now we got 8, count them, 8 coming tomorrow. So, they'll take the court probably 8 a.m. or 9 a.m. and they will plow through, and some of them will be big ticket ones. So people will read from the bench, and the Chief Justice will thank different personnel, and then they'll rise in summertime. Okay. Let me just tell you the sort of big ticket cases, just to have them in the back of your mind when they come up tomorrow. There is a First Amendment case involving adult speech, pornography / obscenity, which have different definitions in the law that we don't have to go into. But basically, Texas imposed a burden on adult entertainment providers over the internet to not provide access to any website that offers content more than 1/3 of which is sexual material harmful to minors. And that's its own kind of definition under the statute itself. So they've got to figure it out. If it's more than 1/3, they can't offer it, etc. They sue. among other things, saying there's a First Amendment right and there is there's a long-standing line of cases, and there's less First Amendment right to adult speech, but there's some. Anyway, they say that this is harming the First Amendment rights of others. And the question is Texas's law here? We're familiar with this little wrinkle now. Is it to be evaluated under strict scrutiny because it's a First Amendment concern, and it's very hard for the state to be able to make that justification? Or is it just the lowest level of just rational basis, in which case they just have to say, there's some reason and some fit, etc. So it's a First Amendment and adult entertainment case, but it really will go down to, and this will be the, debate in the court to, what level of scrutiny. Okay, so that's one pretty big one. Another pretty big one that is pending, I would say there are sort of two or three that'll make the headlines. There is the so-called birthright citizenship case, but as we talked about at the time, it's not a birthright citizenship case. Although the statute is involved, the justices, and they have the power to shape in their granting of a petition for certiorari, meaning we will look at the case, the question in front of them. And the case also concerns, and the justices have focused only on, when can you give nationwide injunctions? That's something that not simply Republican administrations have been chafing at. And, a judge well, let's do it on the side that would, irk the, say, Biden administration, a judge, Matthew Kacsmaryk, in issues an injunction nationwide having to do with mifepristone. And does that mean at that moment it applies everywhere and the Department of Justice has to put the brakes on everything it's doing? Or should it be rather that it's just in that little duchy of Texas where Kacsmaryk practices, and they go for him specifically to get the nationwide injunction. Now, here's the thing about the case. It was a muddled argument. I listened to it, and it seemed to me that the court was saying, look, we don't want to never permit nationwide injunctions. And in particular, and this comes up with the Trump case, a good example is what's happening with the universities. If there's no such thing as a nationwide injunction, the administration can just go, or any litigant, but it's the administration that is the national player, from court to court to court, lose and not appeal. So there's no further consequence except in that little place. Go to the next, go to the next, go to the next. What's the downside for them? They got, they're the feds that can do. They got a lot of resources to do it. So really, does it make sense that the justices were puzzling over this, that they never get to, their chance to make a ruling and things apply nationwide? And if that's the case, doesn't some lower court have the ability to impose a broader injunction? On the other hand, the specter in a normal case, maybe in most cases, that one judge, perhaps plucked out strategically by a party, makes the ruling and then just boom, applies it to the whole country. Everybody has to stop in their tracks, the Department of the federal government as well. So what do you do? And the feeling that I got in the argument was basically that they want to say there's sometimes, but it should be rare. And that, to me, so we'll see what happens tomorrow, but is usually a harbinger of, some kind of mucky, amorphous Supreme Court case is coming around that's going to give district courts fits trying to apply it. But it seemed to me they were going to struggle after the argument. They didn't get sort of clean standard to really fasten onto, and they're going to be struggling during this time to state something. And typically that means it's, amorphous and remains for district courts to work out. We'll see. The other possibility would be a clean forget it on nationwide injunctions. That would be the other, because they're never going to say, you can always do this practice. Okay, so that's the birthright citizenship, but it's really the nationwide injunctions. And then finally, Mahmoud versus Taylor is a case that's really right down the middle of a big theme for this court in particular, and its solicitude for free exercise rights. So the First Amendment says two things, right? It says you can't establish religion, and it also says you can't impede the free exercise of religion. And more in recent years, this was really notable in COVID, say, the Supreme Court, the conservative members of the Supreme Court have construed what might have been establishment clause cases in the past as free exercise cases today. And what do I mean by that? The perfect example, Mahmoud versus Taylor. So in public school, there's curriculums that include, this is in Maryland, some themes related to LGBTQ material, themes, whatever. And there are people in parents who want to say, I don't want my kids exposed to that. Now, if parents said typically, I don't want my kids exposed to algebra, it's the devil's doctrine. Too bad. You're in public school. Public schools get to make certain pedagogical choices. But here they want to play a card that the court's been very solicitous of, as I say, and gives a higher level of scrutiny. What's that card? You are messing with my religious beliefs. My religious beliefs are that my children should not be exposed to this material, and including it in the curriculum impinges on that. So will the court, as it's done more and more in the past, 10, 15 years before that, this kind of analysis would have been unheard of, construe this issue as one having to do with free exercise. And, if they do, I think the majority of the court, maybe the 6 uber conservative majority, is going to say there's a free exercise issue here. We are in June. We're at the end of June, and the very end of the term. It looks to me like the cases and the last few weeks have really been the flexing of muscles of the 6. That includes Barrett. There's a lot of stories about how she's here and there in different cases, but I think we will see. But the portents, as I read the cases, show that the story will be for these last stretch of the court, that it is the sort of lockstep 6-3 and the progressive 3 writing these increasingly laments about what the court is doing, but otherwise being powerless to stop the juggernaut. So the juggernaut is, there's no Dobbs cases overruling Roe, but when you add them up for the term, there's a fair bit. And I think by and large, with some important exceptions, the conservative juggernaut marches on. We'll see. That's my prediction for tomorrow. But in any event, 8 cases, those 3 or 4 will be important. And now you'll be ready to do quick takes on them when they come out, which they will at 10 a.m. Did I say they should take the bench at 10 a.m.? And go through these. It'll take a little while because some of them you may have people reading from their dissents on the bench and the like. And then court's out for summer, except emergency docket and the like. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.